Epitome IAS. So as you know all, we are doing with the mains answer writing program, because most of the times students fail to synthesize the ideas and club together to present a beautiful answer. So in this session, we not only explain the question, and we also explain certain concepts as well, so that students can gain the knowledge and confidence. He can confidently attempt similar kind of questions that can be asked in the examination in future, right? So let us understand this question from the 2025 General Studies paper 2. Okay, so right, if you try to look at the question, constitutional morality is a fulcrum which acts as an essential check upon high functionaries and citizens alike, right? In the view of above observation of Supreme Court, explain the concept of constitutional morality and its application to ensure the balance between judicial independence and judicial accountability in the country, right? So basically, let us understand what is the demand of the question. The demand of the question is that, right, so constitution is not just driven by the text of the constitution or letter of the constitution, even it is driven by the spirit of the constitution, right? So if any functionary is just driven by the letter of the constitution, they fail to understand the purpose of the constitution, they fail to comply with the requirement of the constitution. That's why we require to promote the value system in the country which is promoted by the constitution. That is what called as constitutional morality. And it is also explaining, it is self-explanatory. It says that it should act as a check upon high functionaries as well as citizens alike. Okay, it means the constitutional functionaries shall be bound by this constitutional morality and also the citizens. So in other words, this is promoting the concept of rule of law or equality before law, right? So let us understand one by one, right? So because the question has many components, because what is the question that is asked? In the view of the above observation of Supreme Court, this is the opinion given by Supreme Court, explain the concept of constitutional morality. So it means this particular paragraph, whatever the statements are given, this must be covered under this dimension. Okay, later we need to address this part of the question. So essentially there are two parts of the questions that must be addressed, right? So first introduction, and second, the concept of constitutional morality, and third dimension is how do you apply in order to strike the balance between judicial independence and accountability in the country, and thereafter the conclusion, right? That is how you need to write the answer. Okay, right. So let us understand here. Right. So in the introduction part, you will have to write what is constitutional morality. So it is a 250 word question answer and 15 marks question. So we can write little elaborately also, there is no problem, right? So constitutional morality means what? Okay, it deals with the spirit of the constitution. Okay, so it means the constitutional morality is the manifestation of ideals, values, beliefs, okay, and what else, the objectives or goals that are mentioned in the constitution. So it means the constitutional morality represents or reflects the philosophy of the constitution, the broader purpose, the broader goal of the constitution. Okay, as you know very well, why the constitution has been established, why the constitution has been enacted. The purpose is not to continue the status quo, it is to ensure the change, the radical change to happen in the society. So it means the high constitutional functionaries and citizens, they require to practice the values that are promoted by the constitution. Okay, right. So you cannot distinguish that only constitutional functionaries are required to follow the constitution. Even the citizens must also be bound by the constitution. Why? Because citizens themselves are the spirit behind the constitution or source of the constitution. Because we can find we the people of India in the preamble, this indicates that people act as the source of the constitution, right? So let us explain this concept of constitutional morality, because the question is asked, okay? The question is asked in the direction, right? Then how do you explain constitutional morality, right? So constitutional morality is required to be respected and cherished as well as followed by citizens and high constitutional functionaries. Okay, why? Because constitution is the supreme law of the land. Because constitution is supreme law of the land, right? And the constitution seeks to radically restructure the society. Hence the crux of implementation or enforcement of constitution is insufficient if we focus only upon letter of the constitution. Letter is insufficient, okay? We need to understand the broader goals and perspectives of the provisions of the constitution, right? So that's how the value system promoted by the constitution is required to be followed by the constitutional functionaries as well as citizens, right? So let us explain how it is applicable for the constitutional functionaries, okay? How is it relevant for constitutional functionaries? This is how you need to explain the answer, okay? Write the answer, okay? Constitutional functionaries, right? Because our constitution establishes responsible government, okay? And government has to be responsible, and it has to ensure both authority and responsibility must commensurate with each other, right? For example, the government has the power to frame the rules and regulations for the laws enacted by the legislature. So that power is called as delegated legislation, okay? Quite often what happens that the rules framed by the government may be going beyond the very purpose of the law, okay? The rules and regulations drafted by the government may go beyond the sphere of authority that is provided by the law. So it means it has to confine its delegated legislative power within the sphere of law, This is nothing but constitutional morality. Why? Because constitution is expecting the government to be responsible, okay? Right. And similarly, conducting the question hour, zero hour, and proceedings of the house without any disturbances, right? Why? Because in the parliamentary form of democracy, what is required? Prime Minister and Council of Ministers are collectively responsible to Lok Sabha. This is not possible unless and until the proceedings of the House are happening in the very a serene manner or in a constructive manner. So that is very important. And moreover, even leader of opposition, how the leader of opposition has to behave. The leader of opposition has to conduct himself in a constructive manner. So he has to ensure constructive criticism. This is also according to constitutional morality, right? Because any institution that is established by the constitution must promote the values which are mentioned in the preamble, right? Justice, liberty, equality, fraternity, dignity. So this is all the values must be followed by the high constitutional functionaries, right? Then suppose if you try to see, non-appointment of the speaker, deputy speaker, not choosing, we can say, not choosing deputy speaker in the successively second Lok Sabha, that is a departure from constitutional morality, because the presence of deputy speaker in the Lok Sabha will ensure the bipartisanship of the Lok Sabha. Bipartisanship means there will be a balance between role of speaker and deputy speaker. So speaker usually represents the ruling party. Of course, in the parliamentary form of democracy, speaker is not supposed to be the representative of ruling party, but operation of the Indian democracy showcases the fact that speaker is trying to defend the interests of the ruling party in the Lok Sabha. So in that context, it should be the deputy speaker to represent the opposition party, so that there will be bipartisanship. If deputy speaker is not there, that is nothing but the departure from the constitutional morality, right? Similarly, criminalization of politics. If political parties are encouraging criminals to enter into the politics, that is also against the constitutional morality. Of course, in the constitution nowhere it is mentioned about criminals and other things, but still if you go by the very interest of the people of the country, if you try to go by very purpose of the Indian constitution, definitely the criminals shall not be encouraged into the political system, right? So this is how you need to write various dimensions. What is about opposition party, what is about ruling party, what is about parliament, okay? And you can also mention about judiciary, okay? So for the judiciary there is a separate dimension that is there. Of course you can mention here. So even judiciary must also be following the constitutional spirit and constitutional morality. For example, Justice Ranjan Gogoi's incident, okay, indicates that the judiciary has departed itself from the principles of natural justice. So even following the principles of natural justice in the functioning of various institutions is also according to the constitutional morality. This is how you can present the answer. Even judiciary has reflected this constitutional morality in various cases. For example, we can say Puttaswamy versus Union of India case, okay? So by declaring right to privacy as a fundamental right under Article 21 of the Constitution, right to privacy, right to privacy. So this indicates the concept of limited state or limited government, okay? And we can say Nalsa case, transgenders have been recognized as third gender, okay? Similarly, SR Bommai versus Union of India case, SR Bommai case, okay? So in this case, Supreme Court declared secularism is a basic feature of the Constitution, okay? As well as we can say Keshananda Bharati case, where Supreme Court declared the concept of the doctrine of basic structure, thus imposing the limits upon the power of Parliament to amend the Constitution by affecting the fundamental nature or fundamental pillars of the Constitution. So that is how the judiciary has also reflected the constitutional morality, and it is required to respect that in the other aspects also, okay? This is how the high constitutional functionaries should follow the constitutional morality. Even for example, President of India, if you try to see President and Governor, their oath is similar, okay? The oath is that preserving, protecting and defending the Constitution, preserving, protecting and defending the Constitution. Not only that, devoting themselves for the public service. So naturally, wherever the public interest involves, the Governor and President must act according to the spirit of the Constitution, right? Whether the bill or act, whatever it is there, is it really serving the purpose of the people of the country or not? Is it really serving the interest of the people or not? For example, when Office of Profit Bill has been presented by the UPA government to Abdul Kalam, he has returned that particular bill for the reconsideration. Why? He has been driven by what is the oath of office. This oath of office is also reflecting the constitutional spirit, constitutional morality, right? So because they try to protect their own interest, okay, trying to protect their own interest by exempting certain offices from being called as Office of Profit, right? That was actually resisted by Abdul Kalam. Of course, it was further overridden by the Parliament, that is a suspensive veto, but still we can take that as an example. And moreover, there are various matters where we can see the constitutional morality in the functioning of the high constitutional functionaries, okay, right? Then what about the citizens? Okay, even citizens must also be respecting the constitutional morality, right? So because citizens are source of the constitution, the people of the country are source of the constitution, because the preamble itself declares. Okay, so and moreover India is republic, so republic indicates popular sovereignty. Not only popular sovereignty, the people have to defend their constitution from any kind of degradation, any kind of violation by internal or external forces. So that is what called as popular sovereignty, right? So citizens have to abide by the value system of the constitution. For example, if you take fundamental duties, that mentions every citizen should follow the values of the constitution, institutions, and he has to renounce the practices derogatory to the women, and inculcating scientific temper, not destroying or not spoiling the public property, protecting environment, cultural value system, as well as monuments. Okay, and even sending the children to the schools, particularly 51A class K. Okay, giving opportunity for the children between 6 to 14 years. So it means this explains the responsibility of the citizens in contributing to the development of the society and promotion of the interest of the country, right? Even citizens, of course, according to Gandhiji, rights and duties are two sides of the same coin. So if the citizen has to enjoy his rights, he must also be dutiful. Okay, so this idea, even fraternity is also very much important. For example, according to Dr. B.R. Ambedkar, Indian society lacks a social democracy. You must understand, Constitution tried to give one man, one vote, one value, and it also given value system as well. But if the people do not change their value system, the very purpose of the Constitution will be defeated. That's why they must be promoting fraternity. They must not be encouraging the fisiperious tendencies that is actually given by Article 51A, Clause E, right? So sectional, linguistic, religious kind of hurdles shall not be limiting the fraternity of the people. So that is how citizens have to do that. Okay, right? Even Article 17, abolition of untouchability. This has an internal message. It is not just a method to punish the untouchability, but it is a message to the people. Yes, untouchability is to be abolished, means untouchability shall not be followed. That is what the direction given by the Constitution to the people. Okay, we have given our own directions. That's why citizens have the responsibility to fulfill the constitutional mandate. So they are required to follow the value system of the Constitution. This is how we have explained the concept of constitutional morality. So particularly with respect to high constitutional functionaries, we have to explain what is the case with president, governor, judiciary, ruling party, opposition party, parliament. Okay, even the functioning of governor. For example, governors are very much recently in the news because they are purposefully delaying the assent over the bills. So if they delay the assent over the bills, they are obstructing the governance at the state level. If they are obstructing the governance at the state level, they are promoting the subordination of the states to the center. So if they are promoting that way, definitely it is a violation of federal features of the Constitution. Supreme Court held that federalism is also basic structure of the Constitution in SR Bommai case, right? So misuse of the presidential rule, this is also going against the spirit of the Constitution. One thing we need to also tell, okay, yes, because Constitution provides principles. Okay, these principles might not be clear all the times, right? These principles might not be clear all the times because there will be gaps, because society is evolving, definitely new kind of questions that would arise. Okay, so these gaps are to be filled, okay, by democratic reasoning, okay, and aims and objectives of the Constitution. Okay, for example, preamble promotes the egalitarianism. Okay, for example, Indian state is welfare state. Okay, the purpose of establishing welfare state and the purpose of promoting egalitarianism must be driving the institutions to understand the constitution. Right? For example, whether transgenders should be given equal rights or not. Yes, they need to be given equal rights. Why? Because Article 14 promotes equality before law, and we need to be welfaristic in nature. Okay, welfarism does not lead to discrimination. Okay, discrimination must be abolished. So, and even institutions have to be very much prompt in their response to safeguard the rights of minorities. That's why judiciary has come up with various judgments, okay, promoting the interests of minorities and helpless people. It has opened the window of public interest litigation. That is also again according to the principle of constitutional morality. Okay, so this is how, right? Even government is promoting e-governance. So e-governance will ensure the reachability of the government to the nooks and corners of the country, and where the citizen voice can be heard by the government. For example, mygovernment.in. Okay, so where it is promoting the spirit of republican nature of the constitution, where people can come up with the alternative policies. Right, this is how we are able to see the constitutional morality. But however, there are certain departure also, like unavailability of that means not choosing the deputy speaker. Okay, and Indira Gandhi's government has not elevated the senior judge of the Supreme Court as a Chief Justice of India, and it has promoted junior judges. So that is also departure from constitutional morality. And judiciary, particularly Ranjan Gogoi incident and Deepak Mishra incident, these indicate there are certain problems in judiciary also. For example, judiciary did not initially open for RTI. It has to we needed to wait almost 7 to 8 years. Okay, only after Subhash Chandra Agarwal has successfully fought the case at various levels, judiciary got convinced to open the judiciary itself for the Right to Information Act. So that is how the constitutional morality has certain challenges. Even from the citizen side also there are challenges. Even today we are promoting casteism, we are promoting communalism, we are promoting regionalism. Okay, these are all against the purpose and spirit of the constitution. This is how we need to present the explanation regarding the constitutional morality, right? So you can write many points, but we cannot accommodate all the points in the given answer, because we have limited number of words or space given in the paper. But however, the explanation must go in this direction, right? Then what else? Then, in the view of the above observation, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability. So both must be given equal space in the answer, okay, in the body of the answer. Right? Let us understand here its application to ensure balance between judicial independence and accountability. Right? How constitutional morality has to be applied in balancing judicial independence and accountability. Yes, its application to ensure balance between judicial independence and accountability. Right. First of all, you must understand what is judicial independence. What is judicial independence? Judicial independence means the functioning of judiciary, the organization of the judiciary and functioning of the judiciary must not be dependent upon, okay, must not be dependent upon other organs of the state. So it means the function, we can write this way, the functioning of judiciary shall not be interpreted or interrupted, shall not be interrupted by the other organs of the state, okay, in discharge of its constitutional obligations or responsibilities. Okay, so that is what judicial independence. So it means Constitution has carved a separate sphere, for the judiciary, to function. Okay, what is the sphere? The sphere such as judicial review, okay, interpretation of the Constitution, okay, resolution of disputes in the society, resolution of disputes. Okay, promoting rule of law, rule of law. Okay, protecting the rights of the people, protecting rights of the people. So these are all the separate sphere that is demarcated for the judiciary. Okay, so this area of judiciary shall be immune from the interruption by the executive, interruption by the legislature. That is what called as judicial independence. And moreover, and how do you exercise this judicial independence? So judicial independence is not to promote the personal interest of the judges. The judicial independence must be based upon the interest of the people, that is the constitutional morality. So it means this judicial independence must be founded on constitutional morality, founded on constitutional morality, right? So how do you see that? Means, in fact, Indian Constitution promotes principle of separation of powers. At the same time, we also find the principle of checks and balances, Okay, so separation of powers means every organ has to perform its function, its own designated sphere that is given by the Constitution, allocated sphere that is given by the Constitution. But at the same time, if one organ violates the Constitution, the other organ will try to rescue the Constitution from that violation. That is what called as principle of checks and balances. So it means the judicial independence must be serving the interest of the Constitution. Okay, so it means the judiciary shall not be indulging in overreach. Shall not be indulging in overreach. Okay, overreach means interrupting the other organs to function. Rather, it must try to serve the purpose of the Constitution, right? So how do you see the independence of judiciary? So independence of judiciary is seen in the form of collegium system. Article 145, power to frame its own rules. Article 146, regulation of its own staff. Contempt of the court. Okay, contempt of the court. Court of record. Okay, right? So these are certain powers, like their expenses are charged on Consolidated Fund of India. Okay, so which is not votable expenditure at the stage of demands for grants. So likewise, the Constitution has provided the independence for the higher organ of the state, that is Supreme Court. Okay, so even High Court also enjoys the equivalent powers like Article 215, 217, 227, okay, 228, where the subordinate judiciary is superintended by the High Court, not by the executive. Separation of judiciary from executive. This is all providing the sufficient basis for the independence, right? Okay. At the same time, what the judiciary must be? The judiciary must be, what is it? Accountable. Judiciary must be accountable. What is accountability? Accountability means answerability. Okay. Accountability means liability or answerability. Answerability for the omission or commission, whatever it is. Whatever the functions they perform, they must be accountable, right? So it means the Constitution does not anticipate any organ to be only enjoying the authority without responsibility. So authority and responsibility must be co-equal. They must be equal with each other. Responsibility must be equal with each other, right? So constitutional morality must be guiding the judiciary to be equally responsible, not only enjoying authority this way, it must also be shaping the responsibility of the judiciary, right? So what is a example how the judiciary is trying to stand by this concept of accountability or responsibility? For example, so Justice J.S. Verma has drafted reinstatement of judicial values. This is known as Bangalore Principle. Bangalore principle. So how the judiciary must be following the certain ethical norms, neutrality, independence, integrity, non-partisanship, such kind of values they need to promote, okay, in the discharge of their functions. That is given by Justice J.S. Verma when he was Chief Justice of India in All India Judges Conference conducted in Bangalore. That is popularly called as Bangalore principle. So the very basis for this particular thing is definitely the constitutional morality, because judiciary felt that they cannot enjoy just authority, they need to be responsible, right? And not only that, we can also see in-house mechanism. In-house mechanism. So in-house mechanism is to investigate the charges which are leveled against the judges of the Supreme Court or judges of High Court. So that will ensure there should be some mechanism to respond to the allegations, so that the public trust over the system will be maintained. Why? Because people are the the sources of authority for any constitutional functionary. So that is how. And not only that, judiciary is also following judicial restraint. Judicial restraint. Judicial restraint. Judicial restraint means judiciary not to interfere into the policy questions of the government. So judiciary has to restrict its role only to the designated space that is given by the constitution. So it is an kind of corrective mechanism against the judicial excess or judicial overreach. So that is what called as judicial restraint. In USA that is called as doctrine of political question. Doctrine of political question in USA. So where the judiciary does not involve into the areas where there is a political question is involved, right? So that is how. And not only that, not allowing PILs which are filed on the basis of frivolous basis. The frivolous or false, or in order to settle the personal scores, if the PIL is filed in the court, the judiciary would prevent it, okay. And judiciary will ensure the speedy resolution of disputes by means of Lok Adalat. Lok Adalat. So NALSA is responsible, and the second senior justice of Supreme Court is the executive chairperson of NALSA. And judiciary purposefully try to promote this kind of alternative dispute resolution mechanism in order to address the disputes in the society, so that people will be living in the litigant free life, right? This is how. So judiciary is not only enjoying authority this way, and judiciary using that authority in order to serve the needs of the people, and that is making the judiciary to be accountable and responsible, okay. So judiciary has to balance its both authority and responsibility. But however, there are certain criticisms against judiciary. There are certain criticisms, okay. What is the criticism? Okay, judiciary is claiming more authority rather than responsibility. Example, delayed acceptance of judiciary, that is Supreme Court, for RTA. That is number one. Number two, judiciary, despite there are criticisms against collegium system, judiciary is very much resistant or very much adamant to change the collegium or to reform the collegium, okay. Resistance against reform of collegium. Resistant against the reform of collegium. And not only that, okay, allegations on chief justices. Allegations on chief justices. Example, Ranjan Gogoi has inquired his own case, so thus violation of principles of natural justice. Even 4 senior judges have conducted media conference against the then Chief Justice Deepak Mishra. For what reason? He was showing favoritism in allocating the cases to various benches. Okay, so senior judges were not given priority in the allocation of the important constitutional questions, right? And so you can find other reasons also. For example, judiciary is not having a proper system to receive complaints against the judges. So how come a common man can go and approach the Chief Justice of the country, right? So this is how judiciary is showing certain problems with respect to its commitment to constitutional morality. Okay, so that's why constitutional morality must balance what is it? Judicial independence, at the same time accountability. So judiciary cannot, because more for example more authority and lesser accountability, what will happen? The judiciary may become dictator. Okay, more accountability and lesser authority, definitely what will happen? Judiciary will become inefficient or ineffective. So that's why we need to strike the balance between judicial independence and accountability. Even judiciary is very much adamant in accepting MOP, Memorandum of Procedure, regarding the appointment of judges, right? So this is how we can write some points. Even collegium is not open for RTA. That is also not according to the spirit of the constitution, because Republican polity emphasizes people will be the watchdogs over the government. And how does the watchdog role will be fulfilled? It will be fulfilled only if you are implementing Right to Information Act effectively. So there are too many exemptions for RTA. So that is also highlighting the lapses with respect to the system, right? This is how you need to understand the question and write answer, right? So I think we have completed or fulfilled the demand of the question. So we have explained what is constitutional morality in the introduction. Thereafter, we have explained the concept of constitutional morality, right, and which is applicable to different constitutional functionaries and citizens as well. We have explained how it is promoting judicial independence, right, and how this particular judicial independence must be balanced with the accountability. What is the purpose of balancing the independence and accountability? Why? Because why the judiciary has to be independent means that is driven by the constitutional morality. Okay, so we can write these points also. For example, why judiciary should be independent? To protect public interest. To protect rights of the people. To interpret constitution. Okay, all these functions must be done only according to the value system of the constitution. You cannot go against the values. Okay, for example, judiciary has given a direction to mandatorily sing national anthem in a particular cinema theatre, for example. So tell me, is it going in the line of the constitutional morality? Certainly not, because judiciary is trying to assume more powers than it is sanctioned by the constitution. That is not sanctioned by the constitutional morality. Okay, right? Supreme Court involving in the policy questions, that is also not according to the constitutional morality. That's why how independence should be utilized by the judiciary, that is driven by value system of the constitution. And at the same time, how accountability must be upheld by the judiciary, that is also driven by the value system, because our constitution mentions about limited state, limited government. State, what the state has to do, what the state is not supposed to do, that is given in the constitution itself. Hence, judiciary has to observe that particular line. Okay, and judiciary must be self-accountable. At least if it is not accountable to the other organs of the state, it must be promoting self-accountability, right? So, for example, not giving any unnecessary remarks or abusive remarks when the case is heard, that is also a kind of accountability, right? So, because people should be inculcated with a value system by the judiciary itself, by following such values by itself. So, this is how we can see the balance between judicial accountability and judicial independence, and morality will try to bring these two together. Okay, how accountability is important, that is driven by morality itself, because If any wrong judgment is given, that will be affecting scores of lives of the people, and judiciary has a bound and responsibility to interpret the law according to the evolving situation in the society. So, and judiciary in that scenario, it shall not be promoting any patriarchal values or any kind of dominant notions in the society. For example, when Justice Chandrachud was Chief Justice of India, he has published a particular document how to do away with the stereotypes against the women. Okay, how the patriarchal notions must be done away with, that is explained. So, this is how. So, eventually we need to write a conclusion, right? Conclusion. So, what does the conclusion indicate? The conclusion indicates the whole scenario, whatever we discussed in the answer, body of the answer. Okay. So, the conclusion could be, so the constitutional morality is a guiding light for the all constitutional organs in promoting public interest and performing their functions in achieving the constitutional goals and objectives. At the same time, the citizens also have equal responsibility to respect and follow the morality or value system of their constitution, leading to the establishment of the social order envisaged under Article 38 of the Constitution. So, that is how you can conclude the answer. Okay, right. So, then if you try to understand another question here, right, compare and contrast President's power to pardon in India and USA. Are there any limits to it in both countries? What is preemptive pardon? You just understand this is just 10 marker question and you need to write answer within 150 words. Okay, so you do not have much space here. Okay, so we need to be very succinct in answering this kind of question, right? But you cannot just by heart the things and vomit in the examination. Rather, you need to have a kind of conceptual clarity here. What is the clarity you need to have is, first of all, why the president has to have the pardon. So, in the introduction, you will write what is pardon, what is the meaning of pardoning power. So, tell me what is the meaning of pardoning power. Pardoning power means the power to relax or the power to reduce or give exemption from the punishment which is unduly harsh or unreasonable. Okay, right. This is a mechanism is a power, we can say power in the hands of the executive, to correct any potential error in prosecution, because prosecuting agency is what executive itself. So, the public prosecutor or the government will try to establish the case in the court of law, investigating agencies, etc. So naturally there is a chance that sometimes after the court trial happens, new facts will be seeing the light of the day, or there might be some innocence on part of the convict of the case, or sometimes there are other cases, other reasons where the executive may know, okay, because judiciary has to act upon the facts which are placed in front of it. Judiciary does not investigate on its own. So definitely executive has that particular source of information to know that, to verify the facts are right or not. So this is a kind of a corrective mechanism. So the judiciary will try to, the executive will try to ensure the rights of the people shall not be violated unnecessarily because of the errors in the prosecution, because of the harshness of the punishment, or because of the changed facts after the case got convicted, after the accused got convicted in the case. That is what the presidential pardon. So presidential pardon is given under Article 72 of the Constitution. Of course, even governor also has a power, similar power under Article 161. But the demand of the question is only to explain about President of India, right? So now we need to compare and contrast presidential power to pardon both in the case of India and USA. Directly, we need to come into this part of the question directly because very much limited in space, right? So President of India versus President of USA. So this is how you need to compare, okay, right? So constitutional mention. So whether is it mentioned for President of India in the Constitution? Yes, Article 72. Okay. So in the examination you may not get the idea which section of the Constitution of America has provided this, but however you can mention it is mentioned in the Constitution, that's enough. Otherwise, if you have the knowledge, you can write section 2 of American Constitution, right? Then what is a jurisdiction? Okay, jurisdiction of the Indian president is union laws, state laws, particularly in the case of death penalty. Otherwise, it does not fall under his domain. Martial law. But here only federal crimes, and whereas civil cases as well as what else, state related offences will not come under the presidential power. Okay, right. Then what is a case of judicial review? Whether judicial review is available on Indian presidential pardon? Yes. Supreme Court in various cases, Maru Ram versus Union of India, okay, Yepur Sudhakar versus Union of India. There are various cases where Supreme Court said judicial review is available if the executive pardon is arbitrary. Okay, but here it is very much limited. Why it is limited? Because judiciary of America is limited by doctrine of political question. So hence there is some limitation, right? Then so this is how we can differentiate. So decision, who takes decision? Okay, whether the authority, this authority is vested with the President of India on his own, right? This power is discharged on the aid and advice of Prime Minister and Council of Ministers. But the power is vested with the President himself because he is a real authority. President himself. Right? So this is how you can understand the differences between President of India and President of America. Then what is the next part of the question? Okay, whether are there limits in both countries? Yes, basically you can explain. The Indian president is limited by judicial review. Indian president is limited by jurisdiction, because with respect to state laws, the death penalty only the matter which can originally come under the President of India, right? And Supreme Court in various cases has given guidelines, right? The presidential pardon shall not be arbitrary, it shall not be delayed, Otherwise, using the Article 142 of the Constitution, judiciary may grant the complete exemption or relief from the penalty or even death penalty also, right? And the judiciary requires to provide the material, proper material must be there in order to provide the pardon. Okay, sorry, the president has to provide the material. So that is given by the Supreme Court in various judgments. So that is how we can say there are certain limits on Indian president. On the President of America, yes, the state related matters cannot be taken up for the pardon, and the president cannot take, he cannot consider the civil matters for the pardoning, right? So that is how the president, and moreover, the President of America cannot pardon any crime against state. Okay, it is generally pardonable in the case of individual level crimes, but the state level crimes and other things, for example, the president cannot pardon the impeachment against himself, right? So that is how there are certain limits. Then what is preemptive pardon? Okay, so preemptive pardon means the president of India does not have this pardon. Preemptive pardon is possessed by American president only. So here preemptive pardon means the president can pardon himself or his family or any other individual in case of any potential prosecution. If he gets a doubt that in future government may function, may act vindicatively, or it may take up the cases against the persons who have worked in the previous government in a revengeful manner. So those kind of matters can be pardoned by the president. So that is what called as preemptive pardon. Okay, so for example, previous president Joe Biden has pardoned his own son from the potential prosecution that may be taken by the Trump. So that is how. And in the case of preemptive pardons, there is no chance that the judiciary can interfere. So judiciary does not interfere into the preemptive pardons. But in the case of India, there is no preemptive pardon for the president, because we try to establish more responsible government rather than more authoritarian government. So in Indian society, that particular pardoning power may not be suitable. Why? Because governments may pursue their own personal interests. There are too many conflicts of interests in the Indian democracy. So we do not expect this also to be the potential conflict of interest. But in the case of America, they have more political maturity, because their democracy is very much older than that of India, and they have gone through different regimes and different changes. So their public opinion is very much sharp enough to understand the government's functions. That's why preemptive pardon is not there in the case of India. It is there in the case of America. Thus, you can conclude this answer. Thus, both Indian president and American president have the pardoning powers. However, the Indian president has more powers compared to the American president, because he has the power to pardon not only union laws related crimes, and not only that, even state related matters can also be pursued by the president. But however, that there is a limitation that only death penalty related matters can be pursued. On the other hand, American president has more expansive powers, but he cannot interfere into the federal laws. So that's how you can conclude the answer. Okay, I hope you got to know the basic framework of thought process that must be there while you are writing the answer. Okay, and if you have any queries, please comment in the comment box, so that I will come up with different concepts that you require. And moreover, at the Epitome IAS, we are providing digital courses also. So whatever the course we generally make available, that will be very much specific to the needs and demands of the examination. Try to go through the videos, and you can contact the concerned person in the institute, so that you will get all the information. Okay, right. Thank you.